Good morning, everybody. I'll start by very briefly, but importantly, stress that I feel honored and I'm really grateful for being able to speak to you and for being part of this research network, which I find is a pristine opportunity to get into an exchange on really important matters. And thanks very much for your generosity also in hosting us. Thank you. I'll be as quick as I can because this is a really tough topic and we have 20 minutes, so I'll try to be on time. As you said, the title might be somewhat puzzling. I hope I can solve some of the puzzles, maybe. So how does that work? Perfect. So the outline of my talk is I'm going to very briefly sketch some background information on the constitutional background in Germany. We mentioned we had this workshop earlier on, so I'll be very brief on that one, just with an eye to time. Then Professor Varga had mentioned the questionnaire, and I thought, when if not now, am I going to try to respond to these questions? So I'll use the questionnaire as a kind of structure for my talk, and at the end there will be some obviously just tentative conclusions. Tentative because I mean this is an subject which is definitely open to interpretation, and the main idea is that we get into an exchange on that one. Very briefly on the background. Germany has always been a dualist system with regard to international law in general. It has been moderated dualism in the recent decades, but in principle that's still the case. But Germany has also been, as you all know, a founding member of what we call the EU today. So it was socialized, and I might say well socialized, under the supranational regime introduced by the ECJ judgments in Van Gent and Costa. In fact, there was relatively little, maybe surprisingly little, debate about the implications of direct effect and supremacy at the time. And there, I'll get to that later on. Again, there is still no major debate about that at this to this day. The German basic law or constitution hardly provided any explicit basis for such supranationality in the beginning, actually until it was amended in '92 in light of the Maastricht Treaty. And this amendment paved the way for the treaty and in a way codified essential parts of the jurisprudence we had already at the time by the German Federal Constitutional Court. As many of you will probably also be aware, the German constitution does have this highly entrenched structure. It has this eternity clause, as they call it. So some of what they perceived, founding fathers, few mothers, perceived as kind of the core structure is not to be changed, at least not under the constitution. And this eternity clause actually has always been the source of the limitations that the Constitutional Court sees to be in place with regard to European integration. Now, the questions. We did have a number of questions. Some of them will be really brief. Some of them are quite intricate to answer with regard to Germany. You'll see. Now, first question, how are EU legal acts incorporated into national law? That's a very brief answer. As for secondary law, that's automatically no transposition necessary. For new primary law, obviously the consent by the national legislature is required, and depending on whether or not it affects constitutional setup, there might be higher procedural demands also. Second question that we had, has there been any internal examination, legal procedure at member state level of the entry into force of the constitutional treaty and the Lisbon Treaty and its impact on the legal order of the member states? And indeed, yes, the German Federal Constitutional Court did examine the ratification of the Lisbon Treaty in a, book format judgment. And it had done that already also for the Maastricht Treaty, also book format, and we'll talk about that a bit more closely in a second. So very important sources for the matters that we're dealing with here. Now, a question that's requires somewhat more thorough answers. Number 3, on which issues has the National Constitutional Court refused to intervene in order to protect national law and competence, and on what grounds? Now, as a background, starting from the early 70s onwards, the German Federal Constitutional Court, and mind, as I mentioned, without much of a textual basis in the Constitution at the time, the German Federal Constitutional Court has constantly assumed the authority to check legal actions of the EU or its predecessors for resulting violations of the German basic law. So the court did assume such authority very early on. Over the years, the court has framed, developed, and reframed at times the yardstick for this control, and it has come more or less close to hold a legal measure of the EU to be reconcilable with the requirements of the basic law. But it has actually done that only once, right? That's what we already heard Professor Wager refer to, the PSPP judgment of 2020. And since the court has returned to its previous approach, only last week they handed down a judgment which reads very different from what we saw in PSPP, and which very much reminds the reader of the time before. Now, this question, as I said, requires a bit more of a thorough answer. And one of the issues that puzzled me when preparing, and actually throughout our work, is question is, when did the court intervene? And I mean, strictly speaking, they just, as I said, once struck down or held irreconcilable a measure and a legal act of the EU. But I mean, oftentimes we refer to courts as watchdogs, and I'll use that metaphor probably excessively today. Does a watchdog intervene only if it bites? Or is it that maybe even the intended, expected intervention of a watchdog is that it barks, right? And if we think barking is relevant to this question, then I have much more of a story to tell than if we were to focus just on the bite, right? Because actually, the German Constitutional Court has been barking, if you will, for decades, and loudly. And we'll have a brief look at that one. I mean, this is a dilemma. I mean, by redefining intervention so as to include barking, I open up the door for more material to be covered, but at the same time, the material is far too broad to present it here. I hope I'll be able to squeeze it into the written contribution. But there's, I might tell you, a lot of cases, depending on how you count, 15 plus minus, that you would certainly want to take into account, probably even more, of the German Constitutional Court that contained such barking. The issues that have come up, so I have to summarize, can't do the individual decisions at this point. The issues, the areas of conflict that led the German Constitutional Court to comment on the requirements for EU law to be in conformity with the German basic law, where at first mainly fundamental rights issues, so potentially individual violations of fundamental rights. Later on, with Maastricht, actually the Maastricht Treaty, the issue of democratic legitimacy was moved to the forum and at the center stage for a while. Same time, the issue, safeguarding the principle of conferral and of limited conferral, the awkward German expression that made it into international speak, is the competence notion that emerged in the Maastricht judgment, and later on in most recent years, more recent years, more and more the issues were about budgetary sovereignty, so EU spending and liabilities on the national level for that. The criteria that the court developed in these decisions, and mind, they, until 2 years ago, never struck down any of the challenged measures, but the criteria that they developed were really strict and were perceived to be more or less strict depending on the time. And after having issued a relatively strong statement, they oftentimes kind of soften it up later on, etc. But the criteria that have emerged are the ones that I try to list here. One is, in the beginning we were talking about human rights, potential human rights violations. So will measures by EU agents be in conformity with human rights standards as framed by the basic law? This is no longer a separate category because it has been swallowed by ensuing jurisprudence. Second one, and practically the most important one, is the control of ultra-virus acts. So this is basically about, as I mentioned, the principle of limited conferral and the question of whether, the insistence on that the EU doesn't have a competence, so cannot widen its own scope of action. And most broadly, arguably the all-encompassing category is the check of a violation of constitutional identity. I'll get to the question of what that might mean in a second. What is really important about these criteria, however, is that they come with a number of, in a way, general features. One is they are potentially applicable to all measures by EU actors, so any kind of action that can be derived or can be traced back to EU actors, and that has just recently, in the last week's decision, been reconfirmed and strengthened. Second, only qualified violations are relevant. This is a very strong filter. So the court says, well, we check for all these criteria, but minor violations won't count. We won't really interfere unless it's grave. And different ways to formulate that test. The most common, I think, is it needs to be of evident and of structural importance. And lastly, a very important procedural safeguard, get to that at the last question of our questionnaire again, when we talk about constitutional dialogue. The court has put itself under the regime of a practice of asking the ECJ first. So before they might eventually bite, they would give the European Court of Justice a chance to put things straight first. Okay, now with that in mind, fourth question: on which issues has the National Constitutional Court acted in defense of national law and competence, and how and what was the scope of the case from the point of view of the exercise of competence by the EU and of the member states? Well, barking aside, we focus on the bite and too near bite cases. Now, as mentioned very briefly, what was PSPP about? So the one occasion when the German Constitutional Court actually decided to bite. That was in 2020. It was about public sector purchase program that was administered by the European Central Bank and the European Central Banking System. The court did indeed in this case follow its own regime to ask the European Court of Justice to review this first by a request for a preliminary ruling. The European Court of Justice, however, let it pass. And then the German Federal Constitutional Court came in, labeled this decision, and specifically the part in which the European Court of Justice checked for the proportionality of the decision of the European Central Bank. and the German court labeled this application of the proportionality test as simply not understandable and thus objectively arbitrary, because of its perceived failure to engage in a proper proportionality test. And you know, us Germans, we are really confident that if it comes to proportionality, we know, right? So in a way, you see the price for heightening the standard. If you argue that only grave, evident violations count, then of course you're in trouble if you ever express that such a violation has been in place, and obviously quite a tough message to send to the European Court of Justice. And the ultimate holding was a decision of ultra virus. Now there's a major debate in Germany, you referred to that, whether it was a wise thing to bite at all and whether it was the right decision to do that. And I'll mention just two other candidates very briefly for potential biting that we've seen. One is a case on the European arrest warrant in which the German Constitutional Court in 2015 came as close as it gets to finding a violation of constitutional identity. The issue was the extradition requested by Italy on a European arrest warrant of a person who had been sentenced to a criminal sanction in Italy without being present and without being represented in the procedure. So the claim was you cannot, and the thing was the procedure in Italy wouldn't allow for another challenge, a reopening of the case. So the claim was, well, this is contrary to our conception of the rule of law, and that's part of the constitutional identity, so we cannot possibly act on this arrest warrant. But the Constitutional Court expressed all of that and actually said would be against our constitutional identity to do so, but then say, well, you know, but the European Court of Justice certainly would have found the same result anyways under the Charter of Fundamental Rights. So, and we don't even have to ask them because it's so clear. And so they at least seemingly remained in line with the requests of the European Union. So they didn't bite after all, but came really close to that. Now, the most recent judgment, last week's judgment that I mentioned, was about this post-COVID huge spending, huge fund allowing for spending on part of the EU and the respective contributions of the member states. The program Next Generation EU has been extremely controversial, not only in Germany, I think. And certainly people would argue that if the court decided to bite at some point, this might have been a much more important moment to do so. But in light of the history and also in light of the really controversial echo that they got on the PSPP judgment, this one, as I said, reads as soft as it gets and as what we knew for a long time. I had known for a long time the court to be the court's approach. Now, two more questions that we can be really brief with. One is, has the interpretation of Article 2 TEU, particularly with regard to the rule of law, been reflected in the practice of the National Constitutional Court or Supreme Courts, and if so, on what grounds? Second, the interpretation of Article 4, and here the specific regard is to national identity. A brief answer would be no, not in Germany. And the explanation of that is, in a way, historical. As I told you, the whole jurisprudence of the German Constitutional Court predates these provisions. And the starting point, maybe a bit egocentric or overly patriotic of the German Federal Constitutional Court, is not European law in this, but it's the eternity clause and the core elements of the German Constitution. So the court starts from German law and at times notes in passing that these requirements are respected explicitly in EU law as well. Now, completely different question and methodologically quite difficult to answer. How has the academic position changed from accession to the present day as regards the assessment of the impact of EU law on the member states, primacy, relevance of court decisions, etc.? Technically, and speaking about Germany, you would have to cover 50, 60 years of academic debate. And being part of that community, it's of course difficult to really distance oneself sufficiently to know. I'll try to make some, well, subjective, inescapably subjective comments on that. First, the decisions in Van Gent and Costa, as I mentioned, didn't really trigger a lot of debate at the time. Same is true for the German Federal Constitutional Court's insistence that there are limits on European integration. There's wide agreement, certainly in procedural terms. Integration has to follow the rules, and otherwise it doesn't, or further steps of integration have to follow the procedural rules as foreseen in the primary law. Second, also in substantive terms, there are limits. And interestingly, a feature of the German debate seems to be, it always depends on what the structure and the actual state of the European Union is. Substantive limits might be stronger now than at a later stage of European integration. I think we can conclude from that the remaining battleground for academic debate is relatively narrow. It's because all of the premises mentioned before are more or less accepted by everybody. So the debate predominantly revolves around the question of how should the German federal constitutional, sorry, it's not V, but C in the end, court, interpret its role as a watchdog. Now, I've tried very tentatively to list some positions and assign some quantitative weight to them. So those who would like the court to have bitten more often, I think, are in a relatively small minority. There are very few of these. That's certainly not a strong opinion in Germany. Those who think the court should have bitten on other occasions, I think, are more. I think PSPP by many is considered to be the wrong moment to actually concretize, to realize the court's insistence. Those who think the court should have barked less loudly or in a softer voice, I think there are many of them. And the main point in this is you can't bark without biting and see what happens if you bite, right? So I guess that's a relative majority. It's not an absolute term, certainly. And some might even claim that they should just quit being a watchdog at all and stop biting. Again, certainly a minority. And I think the latter two positions are incrementally gaining force over time in the relative balance of this debate. In mind, this is a specific perspective, of course, from Germany, of course, of a member state that has been a member for a long time, that has shaped the EU a lot. And most importantly, I think, as the largest economy within the European Union, there's a lot of self-interest in that. Adherence to EU law, if it comes in exchange for adherence by the others, might well pay off, right? So this could be maybe overly realistic, pragmatic explanation of the debate. Now, last question in connection with the above questions, is the method of constitutional dialogue in force in the member states? Among which institutions has this practice developed? I wasn't really sure whether I could thoroughly answer the dialogue question. So I thought communication might be a better term, at least for my perspective here. And this is because there are many interlocutors of the court, and because I felt competent mainly for looking at what the court did. So what the court certainly did over time is it ensured to be part of this dialogue, to be connected. And it has done so by inventing very creatively an actionable right, subjective entitlement to democracy. You'd be surprised if you were to look into the German constitution. That was an invention of the Maastricht Treaty, and it has been reaffirmed and reaffirmed and reaffirmed, which basically means all integration steps quite alien to the German constitutional procedural setup can be challenged by individual constitutional complaints. So you can read that as making sure that the court is in the business in all cases, right? In all major steps of European integration. The court does send out signals, and it does so selectively because, and that's probably the point behind this filter that I mentioned earlier, it must be structurally relevant, evident violations that they deal with, because they can then get propositions in a way, complaints, but they don't have to act upon it unless they want to. So selectivity in sending out signals is also founded in its procedural approach, and it's being challenged all the time. It's always, you always read passages on, well, is this really a structural or evident violation or not? But probably the criterion shouldn't be taken that seriously. It's about selectivity in sending out signals, I claim. It does send out these signals specifically. So if we pick one pair of interlocutors for dialogue, it's between the European Court of Justice and the German Federal Constitutional Court. And they do send out these signals specifically to the European Court by putting it themselves under the regime of at least considering a referral for preliminary ruling first. But I think they found out that the European Court of Justice doesn't really play along the rules and doesn't respond that much to them. Well, and they hope for responses. So I'll come to an end very briefly, tentative conclusions. There's this saying, a barking dog never bites. Well, they did, and maybe the rule applies only if you respect its message. And I'm sure the German Constitutional Court at the time in 2020 thought the European Court of Justice didn't respect its message. It didn't stay clear of the dog. Very interesting question is, can you return just to barking again? Can they readopt the old approach? And that depends a lot on whether you perceive the bite to have been effective or not. Difficult question and yet to be seen. And what is it actually that our national watchdog in chief has been defending vigorously, at least at times? I think here's an important thing to be noted in our last point I'm making in our exchange, and that is the concept of constitutional identity as defended by the German National Constitutional Court is really minimal, right? And it doesn't seem to be really about characteristics of the German system. I mean, interesting to hear what you think about that. But my sense is that this is what they perceive of as minimal criteria of some core standards of democracy, rule of law, etc. And hence, there's a very common understanding and interpretation of what the court does or of how the court interprets its own role. And that is as a supervisor of the European Court of Justice and the other European institutions. So maybe quite a presumptuous position for the German court to tell the European central organizations, specifically the court, how to perform their task best. So maybe the watchdog is not really watching anything that is particularly German or national part of our national identity, but rather a supervisor of democracy and rule of law in Europe in their own eyes. Thank you very much for your attention.